Okay, ladies and gentlemen, welcome to the Toronto Debating Society for Tuesday, May 14th. Tonight's resolution, be it resolved that the Charter of Rights and Freedoms should be rescinded. To open up the debate for tonight, please welcome our Prime Minister, Dave.
Thank you very much, Madam Speaker. So the Charter of Rights and Freedoms should be rescinded. The Charter of Rights and Freedoms is part of the Constitution Act 1982. Should we define as is obligatory to, and rescinded we define as revoke, cancel, or repeal. My partner and I have 3 points that run along 3 themes that we're going to discuss tonight. The first is a theoretical point of view, practical, and finally a sociological point of view. Now, I'd like to put out there, just to begin, that we are not here to discuss the enormous technical implications of how to actually rescind the Charter. It's entrenched with our Constitution. There is a procedure to remove it if we would like to follow that procedure, but we're not trying to get into that. We simply want to make the case that it should be done. In fact, that it is obligatory, that it must be done. I have 3 main points I'm going to begin discussing. First, from a theoretical point of view, item 1, it is a static document frozen in time. It's a product of the politics of the 1970s and 80s in Canada, and to a larger extent around the world from the 1940s and 50s. In 1982, you have to remember what kind of country we were when we were under Prime Minister Trudeau and his leadership. And even earlier than that, the Charter of Rights and Freedoms was inspired by the Universal Declaration of Human Rights in 1948. Now, it's a laudable goal to try and enshrine our basic rights and principles, but these values become frozen in time when you write them down and make them these cultural artifacts. And that's what you really have to look at. It's history, and you have to remember what kind of world it came out of. The UDHR came out of a world that was trying to find some way of coping with and responding to the 60 million people that were killed in World War II. Now, the Charter was enshrined and introduced into law by proclamation at the same time that the Trudeau government was trying to bring home the Constitution from Canada, bring home the Constitution from the United Kingdom to Canada. And one could argue he was doing this to atone for the War Measures Act of 1970. And I can actually have a quote from Preston Manning saying that I think you can make a case that the Charter of Rights and Freedoms was Trudeau's way of doing penance for the imposition of the War Measures Act during the October crisis. So it's all part of different little cultural vacuums. So we have to look at Canada the way it is today and the way it was back in the 1980s. So why was it important what was important to Canadians at the time? And what was important to the politicians at the time? Well, think about Section 15 of the Charter. I read, quote, "Every individual is equal before the law without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability." Now, what about sexual orientation? This is something that is very important today, very widely discussed, and it's vacant, it's completely missing. Second, consider the technological advancements of today. The word privacy doesn't appear in the Charter. Again, something that's very important today in our rapidly more increasingly connected youth and adults. Finally, Section 33 was a remnant of Trudeau government trying to get Canada to sign on to the Constitution, trying to get Quebec to actually sign on to the Constitution, which something didn't actually work. This is the notwithstanding clause, a clause that actually waters down the document. Now, University of Toronto law professor Kent Roach commented that if the Charter was being written today, it would be very different from the document that it is. And I think we can all agree on that. There are clearly some very important principles here. So in closing about this point, do we really want a frozen cultural artifact which does not change with the social conscious to dictate our most important fundamental rights and freedoms? The second point is that it places undue weight and pressure on the courts from a more practical point of view. From the CanWest Global News Service, quote, "The Charter also forced courts to wade into contested social issues that politicians were unable or unwilling to resolve, such as abortion and more recently the same-sex debate. So the Charter conveniently says that the politicians can dust their hands of it and push it all into the courts to figure out. And that's from a practical point of view. And even worse, some court decisions have even sparked public outcry. For example, R.V. Devote, defense of extreme intoxication, acquitted a man of sexual assault. So something that really rub against the public conscience. And in October 1993, a judge ruled that certain works of alleged child pornography have quote-unquote artistic merit, and charges against the Toronto Man were dropped. And it's not even just social pressure. Its actual workload pressure has increased exponentially due to court rulings that are based on the Charter. So in 1991, 1990, 1985, various decisions of Charter cases had even more workload placed on the prosecution when they had to change the rules around evidence disclosure and all these procedural rules and all these practicalities that were complicated, and the justice system wasn't prepared to handle that. So once again, you've got the charter that was a great idea, but unfortunately puts all this huge work, this huge laborious effort and weight onto the justice system, a problem which persists and is even worse today. Finally, point 3, it favors the rights of the accused over the victims. And this is a sociological point of view. And not to mention just victims, but just ordinary people. Like if you're not actually accused of a crime, what is the Charter of Rights and Freedoms actually doing for you? 2/3 of all charter decisions by the Supreme Court today involve the rights of those accused of crimes. So think about the rights of victims in Canada. It's actually an area of law which is actually quite in its infancy in Canada. Only recently are victim impact statements actually given at sentencing hearings and parole board hearings. This is new. So once again, if we were to rewrite this document today, we would be adding something about victims' rights. What kind of victims do they, what kind of rights do victims have? So it all boils down to this. As a non-accused person, what if the government wanted to appropriate your land? What if the government wanted to decide who you could or couldn't marry? What if the government decided whether you had the right to die or not? These are huge issues. Property rights, the rights to same-sex marriage, and the life debate. With Sue Rodriguez fought very hard for this. And this is something that is incredibly important today. Not this document that is frozen in time. This is undue weight and pressure on the courts and favors the rights of accused over victims and just ordinary people. So the government actually does make these tough decisions. Yes, there are other pieces of legislation that protect you when you're in the airport, when you're in a car, when you're walking down the street. There's all kinds of rules that the government makes. The fact that you have a certain set of dated rights enshrined in the Constitution and other rights that we've come up in the common law or other pieces of legislation which aren't, says that we've got a 2-tier system of rights. So simply by that, we know that the Charter of Rights and Freedoms, as it exists today, as it was created to the letter, the same as it was in 1982, it must be rescinded. We cannot allow this to continue. The Charter of Rights and Freedoms should be abolished. Thank you.
Thank you very much, Mr. Prime Minister. And now the Leader of the Opposition, please welcome Gerry.
Very interesting. I guess the government is justified in having those beliefs and in expressing them. After all, the Charter of Rights and Freedoms doesn't guarantee the right to our own beliefs and in the right to express those beliefs. But we, the opposition, do not agree with their ideas because that too is our right under the Charter. And members of the audience, you are all here in this peaceful, lawful assembly to listen and later express your beliefs and opinions as outlined in the Charter. All of these things which we do in our everyday lives and seldom think about and merely accept are guaranteed in the Charter. Ladies and gentlemen, Madam Speaker, members of the government, I'm going to rebut some of the government's arguments and then I will give 3 points of my own. The Prime Minister first off started talking about a theoretical aspect. But even if we accepted that parts of the Charter are frozen, such as the freedom of speech, we want them to be static and they're entrenched in the Constitution all the time. That's the whole idea of the Charter. Practically, the Prime Minister talked about court rulings. Well, he talked about changes that happen within the courts. That would also suggest that the Charter is not static. There are ongoing changes all the time in the legal system because of the Charter. Finally, he talked about societal ideas where the accused are often where I think he said that 2/3 of the effort goes into the rights of the accused. Well, is that really a bad thing? Whether they're the accused or whether they're the victims, everybody has rights under the Charter, and that is what is really happening. And now for my arguments. For my first argument, the Canadian Charter has a place in our history and a definite notoriety outside of Canada. First, a brief history of the Charter. As you heard from the Prime Minister, It was had its origins in 1948. The United Nations passed a charter outlining people's rights. The Charter of the United Nations was actually written by John Humphrey, who was a Canadian. This magnificent document, which was called the World's Magna Carta by Eleanor Roosevelt, and the Conscience of Mankind by Pope John Paul, became a blueprint for our Charter of Rights and Freedoms. Lester Pearson, commenting on this charter, later said that, and I quote, "No other country has a national purpose, all that is good and noble and excellent in the human spirit." Pierre Trudeau noted that there was nothing in place at that time to stop the government from passing discriminatory laws and violating people's rights. And then, in 1982, our charter came into being as part of Canada's Constitution. The Canadian Charter, which is universally known and respected, has its place in our constitutional history, and thoughts of rescinding this historic document verges on sacrilege. For my second argument, which has to do with the rule of law, I will look at a quote directly from the Charter and the meaning of those words. I'm going to begin by quoting from the Charter. "The Charter was founded on the rule of law and entrenches in the Constitution of Canada the rights and freedoms which Canadians believe are necessary in a free and democratic society. The rule of law, which is the basis of the Charter, states that everyone is equal under the law and has its origins in Magna Carta and later in the U.S. Constitution. The Charter upholds this law and is necessary to guarantee freedom and democracy in Canada. The Charter has the power to revoke Canadian laws which do not follow the Charter's processes. An example could be a law formulated 100 years ago, but which today is not valid. The Charter has the power to revoke or change a law such as this. My partner will go into more detail on this point. Going against the document, such as the Charter, that takes a fundamental part of our legal system and puts it in a special, incorruptible place within the Constitution, cannot possibly be correct. You can't go against this. My third argument has to do with the change within the legal system. Many people believe that the Charter of Rights and Freedoms is Canada's most important law. The Charter has been the main force of change and legal progress in Canada since its inception in 1982. For example, the courts have cited the Charter hundreds of times in situations in order to bring laws into accordance with today's principles of Canadian society. My partner will further expound on this point in his address. Through its use in the last 2 decades, the Charter has been shown to be a tremendous force of positive change in Canada, asserting its point as Canada's premier legal document and the most important definition of our legal identity. Ladies and gentlemen, please use your freedom to vote down this horrendous resolution.
Thank you very much, Mr. Leader of the Opposition. And now the Member of Government will speak. Please welcome Adrian.
Thank you, Madam Speaker. Good evening, ladies and gentlemen. Tonight I'm going to talk to you about the Charter of Rights and Freedoms. The Charter of Rights and Freedoms should be rescinded. I just want to touch on some of the stuff that that the opposition spoke about. You know, that even like the stat. You know, he was talking about how about the static and how it's not frozen, it's fluid. There's freedom of speech and stuff, but there's many reasonable limits placed on that. Even the right to vote is the question with being prisoners today. Courts changed with suggestions that are not static, but what's happening is you're going to see is that there is like a sense where the law has become very much controlled by interpretation by the judiciary. And that these people are not elected people. They usually come from elite backgrounds, and it doesn't help democracy by doing that. The victims' rights do become less important, and this is an important matter because people are committing crimes, and the courts are not able to prosecute them as much and punish them fairly and properly with the law, and this does create some issues also with it. He was talking about having a national purpose, but you got to think about Quebec and how this did not really satisfy Quebec. I'll talk a little more about this in a little bit. I'm now going to start introducing my three main arguments. The first argument is that the Charter of Rights and Freedoms hinders national security. This is a practical side to it. What's going on in the courts, in politics now, in the legislatures, is that there's an attempt to charter-proof legislation. So they tried to, instead of passing security to really apprehend and capture the criminals, they are trying to make laws that they can get through with the charter, and they can pass and they can be accepted, and they're accepting less than happens. There was a court case called Hunter versus Southam. There was a Supreme Court case in 1984. It restrained criminal law investigative powers by requiring warrant issued by judge on basis of probable cause that a search would reveal about a crime, making it less easier to punish them or capture them. Regina versus Tinscombe, the right of the accused to disclose, even with their security certificates, and that caused delayed immigration and prosecute them because they have to go to those proceedings and have all these legal counsels and stuff. My second point is that the Charter of Rights and Freedoms weakens relationships with groups such as Quebec and Aboriginals. This is a sociological perspective. You may be aware there were two accords, the Meat Lake Accord and the Solitown Accord. Meat Lake was in 1987, Solitown 1992. And both were attempts to change some of the stuff in the Charter and the Constitution. And if we're doing that, we've got to question how effective the Constitution really is. In 1980, Pierre Trudeau had to go through a referendum, and he promised renewed federalism. But you can't have renewed federalism without Quebec. Quebec was never considered. They never passed it, never accepted, and it probably created more constraints with Quebec. My third and final argument is that the Charter opens the door to arbitrary, reasonable limits. The Section 1 of the Charter reads that the Canadian Charter of Rights and Freedoms guarantees the right and freedom set out in it, subject only to such reasonable limits prescribed by law as can be demonstrated, justified in a free and democratic society. The thing with it is vague, and some people wonder how reasonable it is. There has been some attempts in the courts, I think with Regina versus Oaks, where they had a two-part test, where first of all they had a measure of how important is the freedom to override, the warrant to override the freedom, and the second part that's about the proportionality, but that still puts a lot of onus on the courts and the judges, and it makes it more from a judiciary's perspective, where we have judges deciding the legislation and they're controlling it as elites. Even too, with Section 1, there are concerns with court cases owing freedom of expression, even life, like what is life, and questions about abortion, like Regina versus Morgenthaler. This concludes my statement. Please vote for the motion. Thank you.
Thank you very much, Mr. Member of Government. And now, please welcome the Member of the Opposition, Dante.
All right, before I begin, I'd like everyone to disregard a commentary made by the government where they mentioned that vote was denied to prisoners. There was a court case called Sauvé versus Canada, which completely annulled that. So let's carry on after that. Thank you, everyone, for having me here. Thank you, Ms. Speaker. And thank you to the government for proposing this challenging and very exciting, very unorthodox change to the way we deal with our government. So great, let's start by saying, what does the Charter do for us? All right, so my partner Gerry told you about, wow, this amazing thing that the Charter has given us. I will give you 2 points for what amazing things the Charter is keeping us away from. And yes, I am going to break Goodwin's Law. All right, let's get started. So the Charter functions as our shining principle of a moral compass, a beacon of where we want to go as a country. Canada is, by definition, a common law country, which means that our legal system is based entirely on the courts. This was before the charter was created, but there was already a pressure put on the courts to interpret the law. We live in a common law country since Confederation. The point is, because we're a common law country, we need certain tools to be able to shape this system into a well-being. The charter is one such tool. It gives us a moral compass with which to sharpen that arrow that is common law and allow our system to evolve using these values that we have already determined to be amazing. Why they're amazing? I'll get to that in my next point. All right, so it's also a catalyst. Because ever since the charter was put out, we have found so many laws that have been unabiding with this moral compass, that have been unabiding with these amazing, direction, the direction that we want Canada to take. Certain laws did not abide with that. So we challenged them with the charter and we changed things. It's a catalyst for change, and that's what the charter is doing for us. And of course, the government would have some sort of problem with the fail-safe mechanic put into the charter, the reasonable limits and the what's called the notwithstanding clause. That being said, that's put in there for a reason. Because we know that written documents can become dated in time, that clause is put in there to allow the court to make a major decision in case the benefit of major society. So that being said, this is a document that provides us with rights and freedoms that we believe are essential to the life of every single Canadian. And by doing this, by giving us this direction, it's given us a good place to go. And I think that that's the main purpose of our charter. That further expands on my partner's comments about how it's incorruptible and it's part of our identity. The charter is our identity. My second argument, before I get to rebuttal, is that the Charter of Rights and Freedom serves as our fundamental protection and guarantee against tyranny. Let's talk about the charter for a second. The basic sections of the charter are fundamental, which allows us freedom of expression, freedom of life, like my partner said, freedom of mobility, the democratic rights, like right to vote or right to be a part of government, to run for office, like all of you did today, and the rule of law, which my partner has already explained. Furthermore, it also provides us with equality, right? And I'm sure the government had some qualms about what was put in there in equality, but as the charter says right on there, everyone is equal in front of the law. Everyone. It's based on the rule of law. All right, so what do these actually mean? Well, let's look back at Nazi Germany for a second. I told you I'd break Goodwin's law, so... Nazi Germany emphasizes the opposite points. Unworthy life was what they used to define Jews, black people, homosexuals, which completely goes against, for example, the fundamental freedoms of life. There was voter suppression, which led Hitler to power, which gave him the dictator powers that he got. Ultimately, yes, these were little changes, but the charter protects us against these legal changes that eventually lead us to a place like that eventually lead us to that grand thing. I will now move on to my rebuttal and what's left of my speech. Of course, the government points out that this was a flash, reaction to World War II and the atrocities. I say yes, and I just explained to you why we need such a thing and why we did the opposite. Of course, the government would go ahead and define that the October crisis, this was a remediation. Yes, the charter is put there to avoid stuff like that from happening again. Of course, the government would say that it's weakened relationship with Quebec, but I think it helps. It's something that we share with Quebec as a national identity. As my partner will tell you in the next few minutes, the charter is an excellent unifying overall idea of where Canada wants to go morally and how our laws should stick to this moral compass. And I ask for your vote and I ask for your attention as my partner summarizes all of our points. Thank you very much, everyone.
Thank you very much. This concludes the formal part of the debate prior to the summation. So with that, please welcome the Leader of the Opposition to summarize the Opposition's comments.
Thank you again, Madam Speaker. Despite everything that the government has said, we, the opposition, stand by our 5 main arguments. As you remember, my first argument outlined the history of the Charter from its UN beginnings to the lobbying of Pearson and later the championing of the Charter by Pierre Trudeau and finally its passage in 1982. You cannot rescind history. My second argument dealt with the rule of law and its position in our Constitution. As I said before, the rule of the law is the basis of democratic societies everywhere, and not anything that we should ever think of changing. My third argument explained how the Charter is the basis for growth and progress within Canada's legal system. This positive force must be kept intact to keep Canada moving forward. My partner's first argument further explains how important the Charter is to our Canadian legal system and how it serves as a moral touchstone or compass for our courts. He states that to rescind the Charter would be turning back the gears of progress. With my partner's final argument, he explained how the Charter protects us against political tyranny and asks us not to rescind the Charter and regress politically and socially. Free speech, the right to vote, the right to assemble peacefully, and many, many others. Do not forget these freedoms or take them lightly. Ladies and gentlemen, we implore you not to bow to the taunts of the government and defeat this resolution. Thank you.
Thank you very much. And now to summarize the government's arguments, please welcome our Prime Minister.
Thank you, Madam Speaker. First of all, ladies and gentlemen, I'd like to call to your attention the fact that the opposition's case had very little sources or references or any statistics. It was all high morality, high speech that sounds good on paper, and that's what the Charter of Rights and Freedoms is. It sounds great, and the rights are apparently amazing. But unfortunately, the opposition doesn't think very highly about rights that aren't included in the Charter, like right to same-sex marriage, right to privacy, right to property. All of these things change. Things change over time. And we actually heard this a lot from the opposition, that things change and there's the gears of progress going forward. Well, it's actually time to cut the anchor that the Charter of Rights and Freedoms keeps us stuck in the 1970s, stuck in the 1940s and 50s, so that we cannot move forward. We have a two-tier set of rights, those that are enshrined in the Charter and those that are not. And that is a big problem. I cannot underscore how important that issue is. To summarize our arguments again, 3 themes: theoretical, practical, and sociological. Along the theoretical point of view, I described about how it is this static document frozen in time. It does not change. It is precisely the same as it was when it was written in 1982. Second, it places undue weight and pressure on the courts. Third, it favors the rights of the accused over the rights of the victims and just ordinary people. Not to mention that it also hinders national security, another practical argument from my partner. It weakens relationships with groups such as the Quebecois and Aboriginals from a sociological point of view. And finally, it opens the door to arbitrary, reasonable limits. So it's theoretical from there. So those are our 6 arguments that explain why the Charter of Rights and Freedoms should be rescinded because of these very serious problems. I beg you not to actually fall to the anxiety that the opposition is going to say that only the Charter of Rights and Freedoms is protecting us from Nazism. That's a completely irrelevant point of view, an irrelevant argument, and it's actually a catalyst and a description about what kinds of arguments the opposition tried to show you tonight. So I would please beg you to please support the motion. Thank you.
Thank you very much, gentlemen. Okay, ladies and gentlemen, welcome back to the debate. Please welcome our adjudicator for this evening.
Madam Chair, members of the government opposition, and ladies and gentlemen, the debate this evening was a fairly serious one. I guess that's how we were ending off the season. The Charter of Rights and Freedoms should be rescinded. And we had a clear definition as far as the constitutional basis and being obligatory to be rescinded, revoked, cancelled, repealed, and the like. And the Prime Minister came up and very clearly said, here are my points, practical or theoretical, practical, and sociological, and here are my points and some examples of it. And I think as far as the argument, that's the way to do it, because again, this is a very serious, and there are hundreds of thousands of documents regarding the Charter and decisions and laws and everything in Canada. So trying to filter that down and distill it to 7 minutes as a Prime Minister is difficult. So We had static, it's a static document frozen in time, and courts are overburdened from a practical sense and sociologically. The rights of accused over victims, as well as some additional newer issues that have come up in recent times since 1982 when the charter was adopted. So it gave a good basis from which to jump off with arguments, as well as an opportunity for the opposition to get their hooks into things and try to argue back. So we actually had a debate as opposed to a pontification of sorts. So the opposition came back as well and argued pretty much point for point the issue of the static nature, practical, and the rights of the accused. This is something like the Sue Rodriguez case or the Morgenthaler case or some other case that people can latch on to would have been effective to say, this is what I mean. This is why we're saying to do it this way. The one counter to the rights of the accused as well was interesting, because everybody should have rights under the law. And as I was discussing with my co-adjudicator, it's sort of, if you go to Vegas and bet on red, keep betting on red, keep betting on red, and it comes up 80%, is that necessarily a bad thing? It's not a bad thing if you're voting on red. It's just externally looking at it, but internally the cases may actually be that way because of the details that are not seen. So as far as, again, so the arguments from the opposition, back from the leader, were weak in the sense that there weren't specific examples that I could personally latch on to as far as arguments and content. The arguments were good as far as counter arguments coming up, but the content was a bit lacking. Your own points came up as far as it being the basis of a 1948 Human Rights Declaration from the UN and using the rule of law and the legal system. So that was carried through, and the points were actually carried along by all four of the speakers. So the arguments were kept up. They weren't lost. The member of government came back and said that the laws are actually controlled by an unelected judiciary. Victims' rights aren't being seen. So reinforcing the government's points that were already stated, and then adding three, and it sort of caught me off guard. Sort of, the government said, the Prime Minister said, well, I've got my 3 points, and then the member said, well, I've got my 3 points. Oh, we've got 6 points here. But they were actually sort of dovetails, so there was support that reinforced the government side as well. And the content was good. You stressed a number of cases, you pointed out cases with examples, as well as again, the Morgenthaler issue sort of got it at the end of your talk there. The seconder for the opposition had lots of energy, and because it's your first debate, it's good, and it's got to be challenged to come up here, especially with this kind of a topic. It's sort of, whoa. Again, I think for me, there were a lot of assertions. The examples tended to be lacking. Nazi Germany was brought up, and again, the idea that it should be used as a force against tyranny, again, leading into the Nazi Germany idea. But I think specifically it would have been useful to say, here's a case, here's why. Here's a case, here's why, to just reinforce things more solidly and say, this is why it shouldn't be rescinded, because this got protected or this was done, or what if it hadn't been there to do that. The summaries, again, were pretty much lockstep with what was stated. Everything was pretty much almost word for word. This is what we told you, and this is one of these prime examples of good summaries. Summations is saying this and this and this and this are the things that we told you. So remember them. And by the way, the stuff they said, well, it's not really that good. And that was brought up as well. The idea as well, the government said sort of a two-tiered legal system in a way through the development of the rights of homosexuals property issues, same-sex marriage, right to life, these have changed as far as the laws have gone, and that these are not reflected in the charter. Contrary from the opposition could have been, well, it's a basis, and the laws need to change, but this basis shouldn't change at all, and the laws should be used. And even if the legal system was overburdened, it's not now, because precedents have been set. So, overall, good teamwork from both sides. I've awarded the debate to the government. The score is 73 to 62, and the best speaker is Dave.
Yes.
This is the magic one. I'm never sure.
Thank you. Adrian.
There we are, winning team. Are we all coming up? All having a happy time here?
Thanks, Bridget.
Thank you, Dean.
Thank you.
Thanks, Dean. Okay, popular vote, please, Margie. Who won for the popular vote?
The popular vote, although close, disagreed with the adjudicator and defeated the motion at a vote of 7 to 6.
7 to 6. Opposition won the. Here. Whoop.
Hey!